Greg Northen. He's an attorney in Cross, Gunter, Witherspoon, and Gouches. It's a Little Rock law firm. He's been there 10 years, and his main area of practice is labor and employment, and we're happy to have him here today. Welcome, Greg.
All right, can everybody hear me okay? Am I coming through? I got a green light. All right, thank you. Okay, so hey, first practice right there was this is going to be an interactive session, I hope, for you folks on Zoom, at home or at work. I'm sorry for all the Zoom jokes I'm about to make, but for y'all in the room, hey, this is your chance to get free legal advice. If you call me after this, you're going to get a bill. So, take advantage if you want, although none of my advice is legal advice. It's just informational purposes only. Ann called me a while back, said, hey, we got this conference coming up. I love speaking to y'all's group. Y'all got some challenging issues in your industry. It's been a challenging 2 years, no doubt about it. And she said, hey, we were thinking about some lessons learned during COVID, and I thought, oh boy, how am I going to narrow this down? Because there've been a lot, and I'm sure most of you all have had some things you never thought you'd experience from an employer perspective. So today I've got 5 topics we're going to go over. I'm going to be fairly brief, but they're the things that I think for 2022 and into next year, based on trends we've seen since the election, trends we're seeing in regulatory changes, lawsuits we're getting. These are all the nuts and bolts. These aren't just 5 topics pie in the sky. I chose these because I thought they would be the most practical thing y'all could take away from this conference from me. I'm not able to go into as much detail as I'd like to on these topics, but talk to your team. Take away these issues. My goal for you all from this presentation is to take these issues back to your internal team after this conference and talk about it. Do we have things in place that are going to protect us from these issues? Have we thought about X, Y, and Z? Do we need to change our policies? I got to hear at the end of our last speaker, if you're still operating off of a 2018 handbook, it's out of date. I guarantee it. 2019, out of date. So it's not the same landscape we're dealing with. Laws are slow to change, enforcement is not. And so that's what we're going to kind of talk about today. We're going to start off with OSHA audits. Get ready. The new Secretary of Labor is Matt Walsh. He is a big union guy. Right now they're focusing on union rights. And listen, I'm going to make some comments that are not intended to be political, but as our last speaker said, everything's political. Matt Walsh was a lifelong Massachusetts, Boston union guy, and now he's the leader of the Secretary of Labor. So there's 3 divisions of the Department of Labor at the federal level. You got OSHA, wage and hour, and immigration. And so they're focusing right now on labor, the National Labor Relations Act. And by the way, that applies to everybody. I know y'all, if you've never had a union, you think, oh, union, not me. Wrong. Get that out of your head. Some of y'all probably have a bargaining agreement in place. Some of y'all may not. But unions are chomping at the bits. There are big bones being thrown to them right now at the federal level through rule changes. They are increasing penalties. They are making it very easy for one worker to collectively establish a petition, or really they're going to card check, which I'm getting off topic already. See, I didn't even pick this topic. It's going to be a lot easier to get a union in your workplace. And that's their primary focus. Secondary is OSHA. So we all knew about the OSHA vaccine mandate, right? Did y'all have fun with that? I know I did. I really thought it was going to go through. It got held up at the federal level. The courts put a stay on it. DOL has now said, you know what, we're not going to pursue that. But there's a lot more that OSHA came out with in the last few years than just the vaccine mandate. And those enforcement, because the vaccine kind of got squashed, be on the lookout for, are you putting safety measures into place for your employees, whether they're in vans or in your office or wherever. Wage and hour, man, I could go on this for an hour, but I'm not. medical marijuana. Apparently, during the pandemic, half of Arkansas went out and got their medical marijuana cards. I'm just letting y'all know. I mean, I'm getting more calls. I mean, this stuff passed in 2015. It came out in 2017 with the regulatory changes. And the first bag of weed was sold in 2019, I think. And in the last 2 years, it has skyrocketed in the amount of employee personnel issues we're having with medical marijuana cards. And on the ballot this fall is recreational marijuana, so get ready for that. ADA medical leave, these are some lessons learned during COVID. Do you know when and how you can ask an employee their medical condition? Do you know when you cross the line of, hey, how you doing, to I am conducting a medical examination that triggers the Americans with Disabilities Act protections and you just violated my civil rights? Those are very important topics, things we've learned. I'm going to just hit on those briefly. And then personnel investigations. This is always something to just look at because the way you've done things isn't really going to be the way you can do things further. It's been a long few years. I had a hard time limiting my little silly memes here, but I just wore a face mask into a speech. Never thought I'd do that before. You've got, I don't know how many of y'all had remote workers. I doubt many, but remote work is here to stay. I know y'all are all having trouble hiring people right now. If you're not, please let me know what the secret sauce is, because I got clients in every industry who are struggling to fill open vacancies, and work is falling behind because we don't have the bodies. And if you do get some of those in, they're not the ones you want or need, and it can even make things worse, right? So hiring and firing, really important right now. It's a very volatile labor market. Not really sure where the end of the tunnel is. Hopefully this year we get a little bit of the unsettling, a little bit of the disturbance settled. So OSHA audits. This is my one slide on this. I'm going to go through these fairly briefly. I've already talked about the importance of OSHA, Occupational Safety Health Administration. They have come out. I literally took screenshots of the guidance. There's a guidance on preparing workplaces for COVID-19 that came out in 2020. They've since come out with 10 steps all workplaces can take to reduce risk of exposure to coronavirus. And then the EEOC has now come out with the pandemic preparedness in the workplace and the ADA, right? Are y'all familiar with those documents? Because that's literally a roadmap of what the government thinks you should be doing to protect your workers from coronavirus. It has not gone away. I know Will Smith did a good job of making it seem like it went away for a few hours at least. COVID is still in the building, and it's an endemic, okay? COVID-19 is not going away anytime soon. China's going back up. Europe's having spikes. There will probably be another variation. The vaccines seem to work a little bit. I don't know how much. Regardless of your personal belief about vaccinations and COVID, these governmental standards are going to be expected to be included in your workplace. And if they're not, you better have a really good reason why you haven't decided to follow the advice of the experts, at least to them, because you can get in an OSHA audit now. There has been an intergovernmental agreement signed between the Department of Labor, the EEOC, and shortly is the National Labor Relations Board, where those agencies, for the first time ever, when they go into your workplace to, let's say you get an EEOC charge of discrimination, something national origin related, the EEOC comes in and looks at your files, and they see something that's outside the scope of their investigation, but hey, you have a wage and hour problem, you have a OSHA problem, and they know that's a problem. Used to, they'd say, not our problem, move it along. Now, they're going to send the file to the DOL, the NLRB, or the EEOC for investigation. First time this has ever happened. And this is a good thing, right? That's what the government is telling us. So if your handbook is not up to date, or your policies or your words just expressed to personnel about coming to work, or if you, ignore a complaint about concerns about COVID in the workplace, then that could be an OSHA retaliation charge, or you have violated the standards, right? If you don't have your 10 workplace steps in place, the Department of Labor is going to want to know why you haven't met those. Workers' compensation coverage. coronavirus is covered, make sure you've looked at your policies. There were a lot of insurance companies who made some subtle but significant changes to your, page 1017, subpoint appendix J, I, EEE 3. They made one little change there, and it may determine whether you have coverage. So if one of your drivers who's in a van full of sick people gets COVID and dies, you now have a fatality on your hand. You have 8 hours to report that to OSHA, and by the way, they just amended the rules yesterday to now create OSHA logs being reported. Your 300s and your 303s have to be reported electronically. So they're going to want it faster, faster, faster. If you have insurance, if you're not self-funded for workers' comp, make sure you understand your insurance policies. Again, vaccine mandates, I'm not here to talk about those. I know y'all are sick of those after last year, but they're still there. If you're a federal contractor and you have one of those certificates of coverage from whatever agency it is, probably CMS, you must have a vaccine mandate in place. And if you have that in place and you don't give the necessary religious or disability accommodations to your workers, you're setting yourself up for a lawsuit. I am working on one right now for a client who we did the analysis, feeling good about it, but they're out there. They're actually happening. Again, the reporting rules have just been, I threw this in this morning because yesterday you can Google OSHA electronic logs. It's more for the construction industry, but people feel like, hey, OSHA, we're not really a contractor. What's the problem? The Occupational Safety Hazard Act covers every workplace with one or more employee. And there's a general duty clause at the beginning of the law that says every employer shall, not should, shall provide a generally safe workplace. Well, what the heck does that mean? I'll tell you what OSHA thinks it means. And if you don't, again, if you're not in compliance with their standards, you need to have a good reason why. Maybe some things are impossible, that's fine. Anti-retaliation. Again, I know COVID exhaustion is real. I've seen some heads in here already show me there's some COVID exhaustion in the room about when is this crap going to be over. I get it. It's tiresome. But if you don't have your supervisors monitoring how they're responding to workers who have complaints as the mask mandates that were just extended for your buses, as those expire and your drivers come forward with some complaints about concerns, then you are going to set yourself up for a retaliation claim if it's not taken seriously. And that's all it takes. A dismissive supervisor telling somebody, quit being you're just a whiner, you're a worrywart. Like, come on, COVID's over, everybody knows that. What are you, some Biden lover? Any comments like that in a charge? And it comes to my desk and you say, Greg, defend me. I'm going to say, get your checkbook out. You retaliated. How much are their damages? I don't know. We'll work on that. But that's retaliation. It's against the law. You can't do it, and you can't allow your employees to do it to their coworkers. So those are important steps to take, and they're not to be taken lightly. Fun stuff, right? I know. I'm just a cloud of sunshine and rainbows today. Again, these are things to take back to your offices, decompress after this conference. You're going to have 1,000 emails to get back to. I know how it goes. Spring break was last week. I'm assuming everybody's playing catch up. But at some point, you need to look at where you're at. Have you had training for your supervisors on some of these issues? There's lots of stuff online. Do you have OSHA posters posted very visibly? Have you considered, are you going to take any steps for mask mandates in your buses, irrespective of whether the federal mandate is extended or not? Do you need to? Are you going to have a plastic partition between your driver and the passengers? I don't know what a plastic partition does. My favorite thing is going into a bank and the teller's like leaning around it, talking to you without a mask on. I'm like, what are we doing here, But it doesn't matter. If one of your drivers feels like it's going to protect them from a deadly virus and you dismiss it, we got a problem. So you need to have those conversations. Some of this stuff is pre-COVID that has come out on the wage and hour side. We're getting lots of DOL audits and lawsuits. The DOL was very silent under Trump. Under Biden, it is not. It's coming out roaring. We're getting a lot of audits. We're getting a lot of lawsuits because employees, guess what? They have the upper hand right now. They're much more mobile. They have a lot of opportunities. So if they know that they're not getting paid right or they feel like they're not getting paid right, they're going to leave you, go to a competitor or some other business, and then sue you, most likely. Wage and hours is incredibly complicated to get right. It's very simple in theory. It is very complicated in practice because there's a bajillion hypotheticals that you can have with something as simple as, hey, record all your work hours, right? How many of y'all put it on your hourly employees to track their own time? Most everybody? If you do, and the employee says, you know, I worked off the clock, they have grounds for a lawsuit if you don't have a time reclaim procedure put into your handbook, or you don't have some training or some meeting with the supervisors where they signed in and you covered reporting off the clock work, right? And even then, I can't dismiss the lawsuit. You'll be in a better position to defend it. But here on, I'll skip ahead. Do I have a laser pointer? Yeah, there it is. The rule of 8. I don't ever want to see a time card with 8 hours, 8 hours, 8 hours, 8 hours, 8 hours, a magical 40 week. That's baloney, and you all know it, because nobody's that punctual. Unless they're showing up early, and if they're showing up early and they're on your premises and they're not clocked in, what are you doing to make sure they're not doing compensable work? Because that's an off-the-clock work claim, and that's all it takes. A lot of businesses are going towards app, tracking time on your app, right? Mobile phones, this is the frontier. I heard the last speaker talk about, y'all got to be flexible. If you have an old clunk time card machine, in one wing of your bus depot that somebody has to navigate to get to, and they're going to walk past 13 potential working opportunities to get there, that's a problem. Put your time card out by the parking lot, your time machine, and if then when they clock in and they're sitting around talking about deer season or talking about, the Oscars or whatever, you say, are you on the clock? Get to work. But if they're not on the clock, you can't say anything to them because you then make it compensable work time. So these things, again, very simple premise of, hey, make sure you record all your working hours. What does that include? And don't get me started when there's text messages from the supervisors or emails that have a timestamp that if you take their time card with 8, 7:30 to 4:30 with a, with or without a meal period, and there's a 5:01 text from a supervisor, that's called smoking gun evidence. I cannot defend you. You have lost. What are the damages? We'll fight that out. But you have that is a losing scenario. So, again, very simple things. The regular rate, I'm going to mention this now. I actually just heard a conversation about, have you all done hiring incentives? You doing bonuses for getting a vaccine shot? You doing discretionary bonuses for something besides your typical holiday bonus? Employee retention bonuses, right? If you stay 6 months, we'll give you $1,000. Please don't leave us. I mean, that's kind of how it's gotten for some of my clients. If you give a non-discretionary bonus of any kind, which is anything that is formulaic in that if you, the employee, do X, then we, the employer, will pay you Y. If X, then Y. That is a non-discretionary bonus, and you just affected the regular rate for overtime purposes. This is an old rule. I hate it. I think it's one of the dumbest things that we still have, but Congress has bigger problems, and they just haven't really gotten to it. So you have to go back and recalculate every week in which overtime was worked, apportion the amount of the bonus across that many weeks, redo the overtime rate, and then pay a differential above and beyond what their overtime rate would have been. Isn't that really frustrating? Y'all are all like, I'm not doing that. Okay. I mean, we're talking about nickels and dollars here. It's not a lot of money, but you'll violate the FLSA, and I have 6 class actions going right now with this rule. And almost every single one of my clients has done it wrong. I wrote an article on this in 2011. It is far and away our firm's most popular article. We track data on that because every time somebody calls and say, yeah, we actually did an article on that, Like, this is crazy. I've never heard of this. It's been the law for 40 years. It's not new, and the DOL has no mercy. So, again, any bonuses have to go into the I have slides where I walk through how to recalculate that. I don't have time today. Okay, so talk to your accountants. Be very careful with accountants. They like to, they're very numbers. So, but you can get a spreadsheet, or if you use a third-party payroll company, some type of administrator, they can do this, but you have to tell them to do it because their contract with you explicitly says we guarantee no compliance with the FLSA or Arkansas Minimum Wage Act. All liabilities on you. We'll do what you tell us, but we're not going to guide you on any legal action. And so when you get sued and you say, hey, our payroll company didn't tell us, you're going to lose. I've seen it pretty much every company. They all have the same language. And then you're going to have to go to arbitration in New York to fight it. Yes, ma'am. Hang on. Let's get a microphone for the folks on Zoom.
So if you give $1,000 bonus and they get it in a week, is that the week you have to worry about the time and a half if they worked overtime?
Yes, great question. The way it works is you have to look at a time period for which the bonus was given. So if it's a annual bonus, like sometimes seniority bonuses, every work anniversary you get will give you $200, $300, $400, $500. That's apportioned over 12 months or 26 or 24 weeks, depending on how you do your payroll. And you take $500 and you slice it up 26 ways, and you put that amount on each week, and it's only the weeks when there's overtime hours, then you have to recalculate that week's rate and cut a new check.
Okay, so what if it's not an annual basis?
If it's a weekly bonus, you got to do it for that 1 week. If it's a monthly bonus, you divide by 4. If it's a quarterly bonus, you divide it by 12. If it's a 6-month retention bonus, you divide it by 12 or 13. Does that make sense?
So do we need to specify when we give the bonuses that it's a
discretionary?
Yeah.
If it's a discretionary bonus, it doesn't go into the rate, right? So if you walk in and say, it's a beautiful day, probably shouldn't share this, but whatever. We just did one at our office because we were like, hey, people are leaving and we need to do something. So we just said, it's a beautiful Tuesday, everybody gets blah, blah, blah. I mean, I'm talking about a $20 gift card is supposed to go into this. Yeah, there's no dollar threshold. It's crazy. And how much will it make the overtime rate go up? 2 pennies. But you have civil monetary penalties, you have attorney's fees, you have liquidated damages. It can go up quickly. So discretionary bonuses don't go into it. Non-discretionary bonuses, I'll give you one more question, but then I got to move on because we got a lot more to talk about.
So if it's $1,000 one-time thing and it's for that week, where do you go to stipulate that it was just a one-time that 1 week? Do you need to put somewhere that it was just for that week?
I would definitely have a memo internally. So if you get audited or sued, yes. You can call it whatever you want, but at the end of the day did you put a carrot out to entice your employees to do something? Stay. A seniority bonus is please don't leave. Retention bonus, a sign-on bonus. A sign-on bonus, this was a tricky one. If the employee can come get hired by you and 3 days later quit and they get to keep their full bonus, that doesn't go into overtime. But if you say, and this is what everybody does because it makes sense, after 3 months of continuous employment, well, you just made it a 3-month, 12-week bonus, so any overtime in that 12 weeks is now affected by that, however much it is. If it's $100, it's very little. If it's $1,000, now you're talking actual money. But that's just one of the issues. Deductions. We saw a lot of companies try to deduct for PPE during the pandemic. Can you do that? Yes. The FLSA, the Arkansas Minimum Wage Act, they have no restrictions against taking a deduction from an employee's pay. However, no deduction may cause an employee's minimum hourly rate to fall below minimum wage. So that includes gas mileage for the use of a personal vehicle. That includes PPE, safety glasses, helmets, whatever you've got them wearing. You know what else it now includes? Home internet. If you're going to let somebody work from home, you've just made their home internet $50 a month, an out-of-pocket expense for work to the benefit of the company, and that has essentially dropped their hourly rate. And if you have them at or around minimum wage, that's going to be a violation, and the DOL knows it. So if you're not paying for some type of an amount to offset, it's really hard because most people already have home internet that they're using to stream Netflix. You know, is that just a work expense? No, but trust me, if you get to the point where you have to apportion how much, you've already lost. So deductions can never cut into overtime or minimum wage rates. And the new frontier is apps. Like I said earlier, if you have employees clock in on a phone and they have to go buy an Android or an Apple to be able to download the app to use, you just made that a business expense. So you can be flexible. When you be flexible and it makes a change to an employee, you have to keep that in mind for compensation purposes. I just want to make explicitly clear, this sentence right here cannot be overstated. Non-exempt employees get overtime, exempt employees do not. But overtime is 1 1/2 times the regular rate of pay. That's what we just talked about. Bonuses, if they get commissions, if they get a shift differential, maybe you got drivers running the early or the late shift, nobody wants to, so you give them 25 cents extra an hour. That has to go into the regular rate to determine the overtime. And it's for all hours worked over 40 in 1 work week. I cannot tell y'all how many times I get my clients say, oh, we're good. No, they never work overtime. I'm like, okay. And they send it, and it's 80 hours, 80 hours, 80 hours in a pay period. That is not the law. If I work 50 hours one week and 30 hours the next week, you owe me 10 hours of overtime. You can't say 80 in a pay period. The law is everything within a work week. That's any 7-day period you wanted to set it. It can be Wednesday to Wednesday, Sunday to Saturday night at midnight, whatever. But it's got to be within a work week. Again, I repeat that because it's so important. Travel time. We had a ton of travel time issues during COVID. The DOL came out with some rules on this. The Trump administration started it. The Biden administration came in and swept them out of the door right away. So it's been a little bit of a volatile legal standard. But if you have someone working remotely, and this is an old rule also, but we've seen a lot of new hypotheticals during COVID, which was if you've got somebody working remotely, but they have to come into the office to get stuff to take back, there's a rule now. It depends on where is their primary place of employment. If they're temporarily working at home, but their primary place of employment is at the office, then that is not travel time that has to be compensated. But if their permanent place of work is at their home, then when they leave to come to the office, all that time driving is now work time, has to go on their time card, right? That's kind of a new deal. Travel time has 5 different federal regulations. Good luck. It's incredibly difficult. It depends on the purpose of the travel. Are you staying overnight? Are you out of town for a special one-day assignment? These are literally out of the rules. I don't make this stuff up. Normal commute is not paid, but it can be, right? So how difficult could this stuff get? Extremely. Hang on one second. Let's get a microphone for a question right here. Folks on Zoom are really happy with me. I just want you to know. I haven't even made a Zoom joke yet.
So if I'm understanding that last example you have, the temporary work from home or the permanent work from home, as long as you're not deducting their time if they have to come back into the office, there should be no issues in that regard as far as their time, correct?
Yeah, you just put it goes on their time card.
Right. So if it's part of their 8-hour day.
Totally fine.
Okay.
But you wouldn't believe how many companies don't put that on the time card. Like, hey, you chose to work. We're letting you work from home. You're welcome. But can you get that report in? We need to bind it and have it out of the office on time.
So what if they get into an accident on the way into work when they're working from home?
Workers' comp. Yeah. Yeah, that's a great question. But yeah, are they in the scope of their duties? A normal commute is not. You know, if I'm driving to my office to start my day and I crash, not my work job's problem. But if my job says, Greg, we need you to run to Home Depot and get, and I don't know why I go to Home Depot, but Office Depot is what I meant to say. Did you go to Office Depot and get some staples, and I get in a crash on the way? Now it's a work-covered workplace injury. And by the way, you got to report that though, electronically. So, and do you have coverage for that? Do you have? Does your work cover personal use vehicles? These are some of the things that have been kind of diced up in insurance exclusion sections the last couple of years. Trust me, and I'm not an insurance guy. Thank goodness. I don't know who can be. So time cards, with the advent of technology, with the quick Zoom meetings and text messages and FaceTime, it's not just Are your supervisors reaching out to your folks at home? If so, that's a real big red flag for wage and hour compliance. Because you have to have all of those time. If they don't match up with the time card, just go back to your office and do a sampling. You know, ask us one department supervisor, do you ever communicate with employees at home? Yeah, sometimes, very rarely. Okay, let me see some emails where you've sent something, and take that time, or you can go through their emails without them. Just ask them and take some time stamps from an hourly worker and take their pay card, and if they don't match up, you lose. Exemptions, this is a small, there's no change, but it has big implications from COVID because you, the employer, get to decide all of your employees who are paid on a salary, exempt, versus hourly, non-exempt. If they're non-exempt, that means they are entitled to overtime. If they're exempt, they are exempted from overtime, but you have to pay them on a salary basis test. The salary basis test says you have to pay somebody a predetermined amount of wages that is not subject to offset due to the quantity or quality of work performed. And you cannot make deductions from the salary other than a few specific examples. They also have to, that's the first prong, the salary basis test. They also have to perform an exempt job duty. There are about 17 exemptions, generally. 3 are the main. Your white collar exemptions is what they're called. You've got executive, so your executive directors are pretty much exempt. You've got learned professionals, so if you have an accountant or a nurse on staff, those might be. It just depends. Not all nurses are, by the way. Or administrative. And administrative is kind of a catch-all. Again, I have slides for all this stuff, but this is a 2-hour training in itself, so I'm just being going through it very quickly. And all the stuff is available online. Just Google DOL, Wage and Hour Division, fact sheet number 17, A through E. You'll find it. It lays out all the rules. So the big DOT, if you have Motor Carrier Act covered drivers, are they driving passenger vans 8 or more, then they're exempt. The drivers and the driver's helpers, but not mechanics, they're not. Just settle one of those lawsuits. If you've got office folk who are administrative inside the office, then did their duties change with all this change in personnel? Because when you make a job exempt in 2018, the job changes over time. As your staff are coming and going, we all pick up different hats we start wearing, right? Or maybe you give up a duty and you're now changed your duties, but your job is still administrative whatever, or general manager, or VP. I love making fun of banks. They have 150 vice presidents. Nobody knows what they do. I have to review job descriptions of Vice President 3. I'm like, what is a VP 3? They love their job titles in the banking industry. Job titles mean diddly. You can call the grand czar of the universe. Pay me $1 million a year. But if I'm cleaning toilets in your business, I'm non-exempt. Because any physical labor, anything that doesn't use a special degree, and anything that doesn't have, the administrative exemption is based off of whether the employee works inside, no manual labor, and whether they have independent judgment with regards to matters of significance. Does anyone know what I just said? Because I struggle, and I've been doing this for going on 12 years. What is independent judgment with regards to a matter of significance? Can they write a check? Does the check have to be approved? Probably, right? You have layers of protection, so somebody's not embezzling money, right? Well, that layer of protection just took away the independent judgment of the exercising checks, right? So this is a very complicated analysis, and when your turnover of your staff has been happening so quickly, I guarantee you have at least one job that has changed, and maybe they gave away that one duty that made them exempt. Or maybe they started doing some more manual labor. Maybe they now have to help with filing. Believe it or not, filing can be a physical activity that you lose the exemption on if it's picking up reams of paper or cleaning out files or you're cleaning the warehouse. Or what is filing? If you're sitting at your computer scrolling through electronic files, it's very different than other filing. So only you all know the ins and outs of your operations. But I'm telling you, if you haven't looked at your exemptions, get a list of your jobs that are paid salary and done a little bit of a review, I would bet a healthy wager at Oaklawn that you have at least one employee who's misclassified. And the liabilities is staggering, because what are you not going to have with a salaried employee who should have been paid overtime? Timesheets. Because they don't have to clock in and clock out. So guess what they say? Every time I get in a deposition with one of them, guess how many hours they worked every week? 75. Woo, they work me so hard. And it's usually the ones that y'all are going to roll your eyes at and say, that's the worst employee I've ever had. We couldn't get them to come to work. And when they were at work, they were playing online the whole day. And then here I am saying, I don't know what to tell you. If you lose the misclassification, you lose. How much is the only question. You got a microphone anywhere?
I think I just wanted you to restate what you said about the exemption and drivers.
Yeah, restate the exemption in drivers. So if you've got DOT drivers, the Department of Transportation, if an employee falls within the purview of the Secretary of Transportation, meaning they drive a big old, dump truck, that's it. If it's got a DOT number on it, commercial, then they're going to be likely going to be exempt. But even if they're not a DOT number, if they're a Motor Carrier Act, that's a special exemption under the FLSA that applies to drivers who carry passengers a vehicle. Well, it's either a vehicle that weighs, the gross vehicle weight ratio has to be in excess of 10,001 pounds, or they drive a passenger vehicle with 8 or more passengers, the capacity for 8 or more passengers. Interstate. Yes. Intrastate. Very good point. If you're in Heber Springs and you're just driving around, it's got to be interstate. Yes. Great point.
Also, state and governmental exemptions from that as well.
Luckily in Arkansas, for wage issues, our state pretty much mirrors federal. If you're exempt at the federal level, you're exempt at the state level. I've never had somebody lose under the Arkansas Minimum Wage Act who won at the FLSA. Great questions. Any more before I move on? I mean, wage an hour, I'm telling you, I could dive in. We got a question in the back. There's no going back. No, I'm kidding. Where to? Here?
Look, I take guns on airplanes to get by with it. So
Woo. Okay, well, that's another issue.
my question is, when did it become allowable that if you have a wreck in a vehicle, that you gain workers' comp coverage and also can sue the employer for liability?
So if an employee is covered by workers' comp coverage, then that is the exclusive remedy. That is the lawsuit. So if somebody's covered under workers' comp, it's in Arkansas, we have an exclusive remedy doctrine, which means they can't then sue. Now, if there's a passenger in the vehicle who is with them, they could bring a private suit. They shouldn't be able to. I guess if you got one going, we'll talk about that after. I'll hang. You got two? I just so happen to have some business cards. Isn't that crazy? That's just nuts. Yeah, I'd be happy to talk about that in more detail. So again, did any job duties change during the pandemic? Did your salaries change? By the way, in 2020 the salaries went up to $35,684. It took a 3-year tiered the salary basis. You have to pay somebody whose salary, there's a minimum. It used to be $23,660. In my opinion, that was pretty low to ask somebody to work an unlimited number of hours, right? But the Obama administration wanted it to go to $47,000. The sky was falling there for a few years. It didn't pass. Trump came in, and at the end of his first term, passed through an increase to $35,684. So if you have somebody on salary who's making $32,000, you violated the law. They have to be paid overtime. It has to be a minimum of $35,684. We are now hearing one of the priorities of Matt Walsh's administration at the DOL is to get that up to $48,000, maybe $50,000. In Arkansas, that's huge. We have a massive amount of administrative positions, probably some of us in here, who are under $50,000 on a salary, and you will go to hourly. So be aware, if that change happens, you need to be prepared you can switch everybody to hourly. A CEO doesn't have to be paid a salary. Good luck keeping them, but The biggest pain is everybody has to track their time if they go to hourly, right? Nobody wants to do timesheets. I get it, but it's required. If you don't have timesheets for your non-exempt employees, there's a separate violation of record keeping alone, and it could be significant because it's up to $30,000 per employee. It can be a lot. Okay, Medical Marijuana Act 98 passed in 2017. Again, I've already tipped my hat to y'all. Apparently everybody in Arkansas, or half of us, went out and got a medical marijuana card. I don't care about your personal beliefs on the use of marijuana, okay? For the purposes of this lecture, we're talking about Arkansas's constitutional rights afforded to every single person in this room, every single one of your employees, okay? That's all we're talking about, although I'm going to give you a little bit of a context. This is a Gallup poll we got from 2021. I don't see the date on there, but I know it's 2021. Look at this, y'all. 68% of Americans support making marijuana fully legal. Medical marijuana is up to 90%. This is the increase in the percentages over the last few years. Here's 2004, 36%. By 2012, we got to 50, and in the last 8 years, we've gone up to 68. This is for Americans' views on legalizing marijuana. Fully legalizing marijuana, 68%. This is the green wave has been coming for a while, and it's here now. We have state-regulated program in Arkansas. We're medicinal only right now. This graph has gone way green in the last few years just to doing this. Mississippi just passed theirs. Mississippi, okay? We're 49 and everything. They're 50. So if we're down, I don't know what's going on with some of the Midwest states, Nebraska and Kansas, Idaho, but they're coming. So it's here. We already have this. This is established law. I'm not telling you anything you probably haven't heard before, but just to be very clear, your policy can exclude marijuana use at work. An employee cannot come to, even if they have, we're talking about medical marijuana card holders right now. Let's say I have a card and I work for you. I can't smoke at home and then come to work. First of all, I violated the law by driving to work, but I can't come to work under the influence of marijuana. Now, what's the hard part about you being able to tell if I'm under the influence of marijuana? There are some people out there who can get by really well with being high as a kite. You may never know. Clear eyes does wonders, I've heard. You have to be able to, right here, an individual or establishment in lawful possession of property is not required to allow any visitor or guest to carry medical marijuana. Your consumers, your clients, the people who use your bus services may need to go get their dispensary pickup, right? It's 2 full ounces every 14 days is how much you can get. It's a lot. Back when this started, I was like, how much is 2 ounces? It's about a gallon freezer bag if it's all laid out. That was actual legal research, I promise. I haven't seen it. So there are limitations on the use, but there's also an anti-discrimination provision. And again, y'all, this isn't a law, this is a constitutional amendment. 53% of the voters of Arkansas 6 years ago said, we want this, and we amended our Constitution. It's the same freedom you have to speech and carry a gun. I mean, even on an airplane is a problem, though, I'm telling you. But it says, an employer shall not discriminate against any individual in the hiring, termination, or any term or condition of employment based upon the individual's past or present status as a designated caregiver. As a qualifying patient. Now, the designated caregiver, those are folks who can lawfully go pick up, like if they have an in-home worker that goes and gets their groceries, they can go get their marijuana from the dispensary and lawfully carry it back to them without being arrested, right? That's what a designated caregiver is. And that's why you don't need to allow marijuana on your buses. And in fact, if you're federally funded, you can't, because it's an illegal narcotic. At the federal level, marijuana is still a Schedule II DEA narcotic. It is so illegal, they don't even allow human testing on it. And except in very rare situations. But all these states are sitting here legalizing it like crazy, and they're just looking the other way. It's it's an anomaly in legal enforcement, but here we are. So what's a past or present status as a qualifying patient? That means if I currently have a medical marijuana card or if I've had one in the past. You cannot refuse to hire me, and you cannot terminate me, and you cannot change any term or condition of my employment based on my status as a card holder, okay? But what if I'm currently using marijuana? I don't have time and we're already running low. I told Ann we'd get back on track, and here I go. Let's get off track. Yeah, right, I know. Okay. There are a litany, it's a quilt work patch of laws, right? And we don't have any federal guidance because it's still illegal. So some states have protections for employers based on current user status. Ours said status as a qualifying patient. Well, I can have my card and not be consuming marijuana. Maybe I need it if my Crohn's disease flares up really badly, or maybe I just want to have it just to have it. You have to have an underlying medical condition, by the way, to get a card. So what else are we talking about when you ask someone, do you have a medical marijuana card? Do you have a disability? And is that allowed? No. So we've got, again, ADA is not going to cover marijuana right now, but there's a real chance the federal level deregulates, and if that happens, things are going to change rapidly. But Arkansas passed a law through the legislature, Act 593, that amended their constitutional amendment passed by the voters, and I'm setting you up for a little bit of a legal lesson, that says any person who is applying for a safety-sensitive job position and who is currently using medical marijuana, meaning they're going to test positive, they can be lawfully excluded from that position. And the reason is, even if I'm never under the influence at work, but I'm driving your bus full of people, and I get in an accident, and I've been smoking every night for the last year, I'm going to test positive. There is no breathalyzer equivalent to alcohol for marijuana. And until the deregulation happens and the government lets some pharma company make $1 bazillion when they invent one, you only have to go on reasonable suspicion. But that's not, that's before. You can have massive liability if one of your bus drivers, full of customers, has an accident and they test positive for marijuana, and then it turns out that we knew that they had a medical marijuana card. We let them drive that van, and we didn't have anything in place to ensure the protection that they weren't impaired at the time of the accident. So that's some real risk to employers, especially in our industry. So they passed these provisions, and so what you do is, and I'm going to do this very quickly, this is pretty nuanced analysis. If you have an applicant, you're supposed to have any position that's safety sensitive designated as such in writing. Okay, you have to have it in writing. It doesn't have to be anything fancy. It can be a yellow piece of paper in your drawer, but it's got to be in writing. So if it's a position in writing, we would suggest you put it on the job posting notice. So this job position is deemed safety sensitive pursuant to Act 593 of 2017. If that's on the notice and they come in and you say, now, you do have to pass the drug test, is that going to be a problem? You can ask that. And they say, well, I got my medical marijuana card. Or sometimes they just come in and whip it out and say, I got my medical marijuana card, because they've been down this road enough to know. And in that instance, you say, okay, well, this position is deemed safety sensitive. So if you're going to test positive, then you will not be eligible for this position. Some of my clients are willing to go a step further and say, if you're willing to cease current use, then we will hire you subject to a clear drug test in 30, 40 days, whatever it's going to be. And if you pass that drug test, then we will employ you. Oh man, where did it go? So you don't have to do that. That's something we've kind of devised, as saying we're trying to be as least discriminatory as possible. And discrimination just means you're treating someone differently based on some category. In this instance, medical marijuana use. So we try to say, go as far as you can without putting somebody who you know is going to test positive behind the wheel of a bus, right? So this is straight out of the law, and all these slides are online. Y'all can have copies of this. but it's available online. Any position in which a lapse of attention could result in injury, illness, or death, including without limitation the operating of equipment or machinery, motor vehicles, that is a safety-sensitive job position. Okay? But what about your clerk? What about your accounting? You have a receptionist? Is that position safety-sensitive? Maybe. But I'm telling you, I've got several clients who say, well, every single job position in our company is safety sensitive. And I'm saying, okay, there's not one position, because if you can't find some positions to direct someone to, say, hey, you're not eligible for this position as long as you remain a current user. But here's some other positions if you're interested in. Again, it shows a lack of discriminatory animus if you can point them, even if they're not qualified. You're trying to help them out. It's not a small task to ask someone who has Crohn's or ulcerative colitis or cancer or AIDS, some debilitating disease, who they've determined medical marijuana is one of the best treatments for them, whether you agree with it or not. It's not a small ask to say you can have this job or give up your pain relief. So you need to be as careful as you can in dealing with applicants and your current employees, because you might have some current employees right now, you have no idea if they have a medical marijuana card. We get this question a lot. We worked hard to get this Attorney General opinion because we just need to know one way or the other. One of the safety-sensitive designations is working with confidential information or documents pertaining to criminal investigations. Y'all have no idea how big of a pain it was because there was not a comma right there. Is it working with confidential information or documents pertaining to criminal investigations? Or is it working with confidential information or working with criminal information? Right? Dadgum commas. Well, luckily, Attorney General Rutledge came out and gave an AG opinion. This is not binding law, but her position is it's working with confidential information or working with files of criminal investigation. So if you've got somebody like your accountant who has access to all your bank accounts, or maybe you've got medical information, HIPAA documents on your clients, I don't know. They could be deemed safety sensitive for handling information, but this is not rock solid, y'all. And if you get it, and there are lawsuits out there right now. There's a guy in the next building named Chris Burks. I've got 2 lawsuits with him right now on medical marijuana. He's bringing class actions around the state because he thinks this is illegal. And a lot of people do. So you need to be real clear on medical marijuana because we're getting more and more and more folks in there. Again, on drug testing, make sure your supervisors are aware of what a good faith belief is, because the only way to get around it is you see somebody, you got to send somebody for a drug test, and you don't want to ask, you got a medical marijuana card where you're getting tested. That could be a change or condition, a term of condition of employment that you just changed for that person based on their cardholder status. That's illegal. But if I walk in and I've got Cheeto dust on my shirt and I'm blaring Willie Nelson and I'm looking a little glazy-eyed, hey man, go get your drug test. For sure, dude. And so if I test positive, now you've got action to take me out of a position that you deem safety sensitive. You gotta be careful with that. Very briefly, ADA medical leave, we learned some things like, the old notion was, tough it out, get to work. We give you PTO, you don't need to use it. Sick leave should be used. And the EEOC is not gonna like it very well, and OSHA sure ain't gonna like it if you don't encourage employees who are running a temperature or may have a viral disease into the workplace. So you need to maybe look at your sick leave policies and try to change this mindset of tough it out, get to work, come on. You have sick leave for a reason. It needs to be taken. Try to have some information about when employees should not report to work. Is this required by law? No, but will this go a long way if you ever get an OSHA challenge? Sure. Last thing on your discipline issues and your personnel hiring. Again, we're on the verge of a labor shortage crisis. I think we're bottoming out. Yep, I'm getting heads no. Yeah, I know how it goes. I sit in an office and I just hear things. Russia's pulling back from Kiev. Maybe and gas will drop. I don't know. Maybe we'll see. But right now we're on the verge of a labor shortage crisis. So pay rates, if you're upping pay rates to get people in, are you treating them, you're going to have comparators for anyone who's not getting the same rate. So if you bring in a new person who's making more than someone who's been there and stuck with you through this horrible time, and they happen to be a male versus a female, or one race against another race, or age over 40, under 40, you've got comparators, and that's a Title VII lawsuit. Just because you're just panicking trying to get some money, we'll pay whatever it takes, give them 18 an hour, I don't care. But if you've got somebody making 16 who's been there longer and of a different demographic, you've got a Title VII issue. We're seeing people change qualifications. Is a college degree required for some jobs right now? Maybe not, maybe so. It just depends on the job. But if you haven't looked at those job postings, those requirements that you put out there, people are looking. I saw a post the other day, somebody was dying because it said master's degree preferred, paying $15, $20 an hour. People aren't going to take that right now. The workforce has a lot of power right now, negotiating power. Are you negotiating with them? Are you trying? If you are, just make sure you keep it even across the board. Look at your metrics for performance standards. The Gen Z and what we call, I'm a geriatric millennial is what they call me. I had a cell phone in high school, so that makes me a millennial, I guess. But everybody below us, geriatric millennials, has a completely different viewpoint on what good employee is. They don't think they need to be in the office. They don't take kindly to being second guessed by supervisors for things. I'm seeing some head nodding. I'm telling you, you'll think this is pie in the sky fluff. It is here now, and companies who aren't looking at ways to have performance metrics for the job at issue. Do they need to be in the office 40 hours every week? If they can get their work done in 32 hours, do they need to be there 40 hours? Can you pay them 32 hours? Do you need to pay them on like a 40-hour basis if they can get their work done that much? Are you going to keep adding more work onto the high performers and burn them out while other people skate by doing the minimum? That's infuriating to a Gen Z. It's infuriating to a lot of people. But I'm just telling y'all, these things, the workforce expectations are changing beneath our feet. Just make sure that if you make any exceptions to any of this, that your documentation is solid, because you're going to have to explain why you did what you did if you're ever challenged. And you don't ever want to be in a position where it was they said, we said, because then you have to go to a jury, and that's a bad place to be right now as an employer. So I'm out of time. I was trying to leave time for questions. If we get a microphone, we got a question right here.
I'll be loud now. So
Okay.
If I understood you correctly, you said if we have passengers or clients that are going to their dispensary, we don't know what they're going there for. Are you saying that we should have that by policy, that we should not allow that trip to happen?
I think you should do whatever you think is in the best interest of your organization.
I want to clarify what you said there. I thought you said that we shouldn't be transporting that on our public transit vehicles.
I don't think you have to, because I guess it depends on if they have a designated caregiver. If they don't, and you're their only mode of transportation, then maybe you need to accommodate that. But if you're a federal fund recipient, I don't think you can.
Well, we're at odds because we're a federal funds recipient and we have safety sensitive, but yet we can't ask someone why they're going to this location or that location.
Listen, Medical Marijuana Act, Amendment 98 applies to employees,
Okay,
not passengers.
But our employees are transporting the passenger or designated caregiver that may have that package.
Correct. And so I'm saying you need to go back and look at it really closely. That's what I'm saying. There's too many variables for me to give you a recommendation, but I would say that, are you having passengers carry marijuana? Don't answer this. Don't answer this. But if you're having passengers carry it right now, are you in violation of any standards? If you are, you got to fix it. If you're not, then can you allow it? Do you want to allow it? Because guess what? Again, marijuana, to a lot of y'all, you're thinking, I'll never allow marijuana on there. 68% of Americans want it to be legalized. So those are going to be your clients going forward. The stigma of marijuana is dropping.
Usage of, that's a different story on the vehicle, but
Correct. Oh, yeah, no, nobody can smoke. If somebody fires up a joint on your bus, they need to be kicked off. I got one more question in the back, then I'm going to get out of the way for our next speaker.
So I have drivers that need to find out their start time for the following day. If either I text them or they call me to find out their start time, do they have to clock in and out to do that?
I get this question a lot. And I have a great answer. You're not going to like it.
I'm sure it's yes.
I think if you send out a text message that says this is for informational purposes only, or you have something in writing to explain it, I do not expect you to respond to this message whatsoever, and it's just 9 a.m., and they understand that's just for informational. There's a rule under the FLSA called the de minimis rule that says any compensable work that is so de minimis, which is Latin for inconsequential or just a smidge of time, the law recognizes it's impossible to capture every single second of the day that somebody works. But there is no bright line rule for when time becomes more than de minimis. So repetitious text messages, a jury will look, the only people who can answer that is a jury. And if you have to get in front of a jury and defend yourself, it's not a best practice. Or you put a minute in their time card. Adjust your pay, put a minute extra. 1 minute. It's not going to break your bank.
Sounds good. Thank you.
All right.
Greg, we do have an online question if we have just a minute for that.
Yep.
Okay.
Real quick.
So from Jason Haley with Fort Smith Transit, he asks, if I have an employee that hangs around, say 15 minutes after the time they were supposed to clock out, then when asked to turn in a time exception for overtime, they say, don't worry about it, just put my time back to actual scheduled clock out time. Do I do it, or could it be an issue? And he asks, and he does clarify that they're just hanging out and visiting about personal matters.
I get it. Jason, great question, and it's going to end on. The FLSA gives employers a lot of authority in dictating when and where you can work. The definition of compensable work time is to suffer or permit to work. I understand they're standing around talking, but unless you know every single topic they're discussing, and who doesn't talk about work with their coworker, even if you're just gossiping about a coworker, that is compensable work time under the definition of FLSA. And if you permit it to happen on site and then you go back and take that time off their time card, I would not do that ever. What I would do is scoot them to the parking lot, have a nice day, and let them talk all they want in the parking lot. But if it's on the premises that you control as the employer, then you're opening yourself up to liability. Thank y'all very much. I hope you got something out of here.